Good afternoon, everyone. Welcome to this webinar hosted by BYU Law School's Future of Antitrust series. The topic up for discussion today is the impact of current antitrust litigation seeking compensation for student athletes on college athletics programs. My name is Brooke Smith. I'm a visiting assistant professor at ASU, where my scholarship focuses on antitrust and consumer protection, and I'll be moderating this panel. We have gathered a very accomplished group of women today to help us think through this issue, and we're very appreciative to them for their time and expertise. Let me go ahead and introduce them to you. Jessica Beringer is a partner at Keller Postman and currently represents the state of Texas in a biometric enforcement action against Meta. Her team recently obtained a $1.4 billion settlement in that case, which is the largest ever obtained by a single state. She also represents consumers in ongoing antitrust litigation, in which her firm is co-lead class counsel. Jessica previously litigated at Quinn Emanuel and Liz Darger. She is the Senior Associate Athletic Director, Senior Women Administrator at BYU. She serves as the sport administrator for a lot of sports: women's soccer, men's and women's cross country, women's gymnastics, the spirit squads, and men's and women's indoor and outdoor track and field. She also oversees human resources and gender equity for the athletic department and is the campus Title IX liaison. She is a Utah Woman and Leadership Project Ambassador and serves on the Big 12 Conference SWA Committee. Hi, Liz. Thank you for being here. Finally, we have Diljit Taylor. She is the BYU head women's cross country coach and the associate director of track and field. She has a storied coaching career, and if we were to list all of her accolades, it would take the entirety of our webinar. So I will give you a few highlights. She has coached BYU athletes to an NCAA Division I championship, 6 conference championships, 6 individual event championships, and 94 All-American honors. This year, she coached 2 BYU alum to spots on Team USA at the 2024 Paris Olympics. She was also recently named to the first cohort of coaches included in Nike's Athlete Think Tank, alongside other legends like South Carolina basketball coach Dawn Staley and U.S. women's soccer coach Emma Hayes. During her own running career, she was a 3-time All-American in indoor and outdoor track and field at Cal State Stanlis. Welcome, ladies. All right, so the current status of the litigation that we're talking about today is that the plaintiffs and the NCAA have reached the terms of a settlement agreement. It has been submitted to the court, but not yet approved. We're going to proceed with our conversation in 2 general parts. First, we will talk to our panelists about the world that we're in now, where student athletes can receive name, image, and likeness funding, or NIL funding, but not direct compensation for universities. And then we'll talk about what the world might look like if the settlement is approved. So we're going to turn to you first, Jessica. Can you give us, and I know there's a lot of litigation history here, but can you give us a brief overview of the antitrust issues raised in the initial lawsuit that led to the 2021 Supreme Court decision, and an overview of that decision?
Sure. So in the initial case, Division I collegiate basketball and football players filed a class action against the NCAA and the Division I conferences, challenging NCAA rules that limit the compensation student athletes can receive in exchange for their athletic services. They challenged those rules under Section 1 of the Sherman Act, which is a federal antitrust law that prohibits contracts, combinations, or conspiracies in restraint of trade or commerce. There was a 10-day bench trial that led to a 50-page opinion in the district court, where the district court judge refused to disturb the NCAA rules limiting compensation related to athletic performance, but struck down the rules limiting education-related compensation available to student athletes. And the court analyzed these issues under a rule of reason analysis, which requires a fact-specific assessment of market power and the market structure to assess whether the challenge restraints, here the compensation rules, how they actually affected competition. And the goal is to separate out those restraints with anti-competitive effect that actually harm the consumer and those that stimulate competition and are in the consumer's best interests. So here, there was no question that the NCAA had monopsony power in the relevant market, but the court found that the NCAA limits produce significant anti-competitive effects in the market for athletic services by artificially capping compensation offered to recruits. The court considered the NCAA's pro-competitive justifications for its compensation rules and rejected nearly all of them, except for that the rules aimed at ensuring that student athletes do not receive unlimited payments unrelated to education could play a role in product differentiation with professional sports. And in that way, they could help sustain consumer demand for college athletics. And finally, the court asked the student athletes to show that substantially less restrictive alternative rules would achieve the same competitive effect as the challenge rules, and found that they met their burden as to education-related benefits, but not the rules that restricted compensation and benefits unrelated to education. And so the court basically found that while restrictions on athletic compensation may be price-fixing agreements, removing them could blur the distinction between college and professional sports and negatively impact consumer demand. So ultimately, she entered an injunction that enjoined the NCAA from limiting education-related compensation benefits that conferences and schools may provide student athletes, but left the NCAA and its members to propose what compensation and benefits related to education means, and to regulate how conferences and schools provide that compensation and benefits. Both sides appealed. The Ninth Circuit affirmed the district court's ruling in full, and then the NCAA asked the Supreme Court to reverse to the extent that the lower court sided with the student athletes. In a 9-0 decision, the Supreme Court affirmed the lower court and rejected NCAA's arguments that the district court should have only done a quick deferential look at the restrictions, and that she committed error in actually doing her rule of reason analysis. Notably, Justice Kavanaugh wrote a concurring opinion that raised 3 important points about the state of the NCAA rules that remained in effect after this case. 1, the court wasn't opining on their legality. 2, after this decision, those rules should be analyzed under the rule of reason framework. And 3, there were serious questions whether those rules could pass muster under rule of reason scrutiny, which seemed to invite further litigation over those athletic compensation rules.
Awesome. Thank you, Jessica. Before we turn to Liz, I'm wondering if you can also connect the dots for us. How did that Supreme Court opinion lead to a place where college athletes can now receive basically unlimited outside name, image, likeness funding?
Well, around that time, the NCAA removed its restrictions, and after that opinion, other plaintiffs filed lawsuits challenging, basically renewing their challenge that they had before to the athletic performance compensation rules. So then third party, it removed the restrictions on third parties being able to have their own deals with student athletes. And those third parties would include boosters or collectives.
So in response to the Supreme Court's opinion, the NCAA removed those restrictions, but it did not remove the restrictions that are the subject of the current settlement that has been in litigation since, correct?
Correct.
And then can you tell us, do you see any sort of broader, a 9-0 decision usually leads us to believe it's not particularly controversial. Do you see any broader antitrust takeaways from the Supreme Court's decision? Anything that was groundbreaking, anything that is affecting litigation outside of this specific NCAA litigation?
That's a good question. I didn't see anything in particular. It seemed like the court really emphasized that one, even proceeding to evaluate pro-competitive justifications is rare. Most cases stop at the anti-competitive effects step. So this was a rare case that made it that far. And the court really emphasized the role of the court is not to overreach, and it's to create an injunction, that honors our antitrust laws, but doesn't go too far. And the court felt that this judge struck the right balance, which I think was a testament to how much time, that court sat through lots of pretrial proceedings. It was a 10-day trial. She wrote a 50-page opinion. And so maybe if there's one takeaway is don't overreach, because, that's not going to look, that's going to be tough for you if you really are trying to get too much. And there's always a balance, right? There's always a yin and a yang for helping preserve competition, but not going so far as to burden enterprise, I guess, since NCAA isn't a commercial.
Yeah, that's very interesting. I also picked up on, the fact that the court got to pro-competitive justifications, which often isn't the case. And there, some people have opined that if there are any pro-competitive justifications, courts are going to be too nervous to weigh them. And so if you put forth those, they're going to weigh in favor of the monopsonist or the monopolist. But in this case, she conducted a pretty intricate balancing test, which is some indication that that is alive and well and was blessed by the Supreme Court. Let's turn to Liz to talk a little bit about the administrative fallout of the litigation history that Jessica just laid out for us. What have you observed as the most significant changes from an administrative and compliance perspective following that 2021 Supreme Court decision and the NCAA's changes after the decision?
Thanks, Brooke, and thanks for having me. Good to be here with Diljit and Jessica today. So first of all, I think is in talking with colleagues across the country, the opportunity for student athletes to now profit off their name, image, and likeness really was largely seen as a real positive. These student athletes work extremely hard, and other students in their classes could profit from name, image, and likeness, but they couldn't based on their athletic ability, and so that was seen as a real positive. However, there are some unforeseen consequences and things that have proved challenging in terms of how to really implement that. And the lack of guardrails around it has made it complicated. And now different state laws and different challenges and how those interact with the NCAA rules. But some things that we have seen is athletic departments across the country then quickly mobilized resources to help educate their student athletes around these opportunities, which is allowed under the NCAA rules. And so how to help our student athletes understand the opportunity that now is there for them, including helping our student athletes learn how they can enhance their brand, how they can build their brand. And so you'll see athletic departments across the country that now have positions or whole units devoted to that and to the education of student athletes to help them see that. And you've seen the benefit of student athletes across the country, men and women who have been able to sign NIL deals with outside companies that have been a real benefit to student athletes and a real benefit to those companies as well. What it looks like in terms of the athletic department then is how are we educating our student athletes and helping them understand what those opportunities are and how to navigate that outside world in a way that they haven't before. And again, because there have been some lack of guardrails, then there's been complications that way as well in terms of understanding what the rules are and understanding how to best equip our student athletes to make wise decisions that will help them and preserve their eligibility, but also give them the opportunity to profit and benefit. You see the emergence of collectives around the country as well. And so then that relationship between athletic departments and collectives, and what does that look like in terms of that relationship? And so you see collectives, working directly with student athletes and prospective student athletes, separate from athletic departments. And so there's been a whole lot that's happened in a couple of years. And really that's been an area where there's been a lot of very quick growth and positive growth in terms of seeing student athletes benefit. but also a whole lot of questions in terms of how the best way to navigate it. And then now, as we'll get into later with the House settlement of how that changes things again.
That's really helpful, Liz. One of the ways that this seems most kind of like the Wild West is with these collectives that you mentioned. Do you observe college athletics programs wanting those collectives to come to them first? Maybe can you expound a little bit on the relationship that you observe between the athletics programs and the collectives, and what the programs would like that to look like?
I'm not sure there's total consensus across the country. I think you'll find some athletic departments that would love to have it them be lockstep together, and other athletic departments that like having it in arm's length and functioning differently. And so I'm not sure that there's total consensus on that yet. And as House comes, we'll talk more about what that might look like now in the future.
Exactly. It might change. So it's both, what do we want it to look like now, and how are we preparing for it to look like in the future? Diljit, we'll turn to you next and take this at a lower level of abstraction, but staying in the world that we're in, where athletes are receiving NIL funding, but we're not to the settlement yet. How have you observed that funding and the opportunity for them to profit on their name, image, likeness, affecting student athletes at a more personal level?
Yeah, for me, I'm definitely a fan of it. I think it's a great way for athletes to understand and build their own brand and learn that at maybe a earlier age. For my sport, it's a little bit different. Most of the bigger NILs that are happening with our athletes in cross country and track and field are with brands who maybe are interested in the pro career of this particular student athlete. And so we have these NILs that have this right to match. And so athletes at an earlier age are having to identify maybe which brand they're going to even possibly represent post-collegiately. And so it's giving them this idea into the professional world without entering it. And that's how we're seeing it within cross country and track. And it varies. We're seeing NIL grow. I think it's been a really positive thing for my women here at BYU, particularly a few that I have that are currently with Nike for NIL deals. That's been really exciting for them. But having that, and it's not just athletically based. I mean, some of it is athletes are getting NILs for really strong social media presence more than just their athletic abilities. And what we're seeing in our sport, though, it is more geared towards athletes who probably will have an opportunity more than likely to sign a professional contract. And so they're signing these NIL deals that with brands where they have a right to match. So making that decision early has to be really important, which is why we're grateful that we have the resources to help support our athletes to make those proper NIL decisions, because you almost are signing to sign later with them as well, and making this professional decision pretty early in your career. Do I need to talk about the right to match a little bit more, or does that make?
I was going to follow up. I don't know if I'm the only one in the room, but I don't know what that means, what the right to match is. Maybe you can explain that for us.
Yeah, this is really unique to cross country and track. So a right to match is a brand will identify a particular student athlete, probably someone who is already has national presence, maybe dominance. And before, those brands would come at the student athlete, maybe their sophomore or junior year, and pretty much want them to leave the collegiate system and sign a professional contract. Well, now the athlete can stay in the NCAA collegiate system, receive this funding, but that brand is going to say, here's this NIL until you exhaust your collegiate eligibility, then we have a right to match. So if anybody wants to come offer you a pro contract, we have the right to match that contract. So they're signing these kids freshman, sophomore year, which allows them to stay in college, but then the brand is also getting the final say if they want to have that athlete later as a professional. So it's a great thing, but it also is something that you want to be able to understand if that is a brand that maybe you want to represent later on. We've had a couple athletes knew that, and within the NCAA, some colleagues of mine where kids are stuck with Adidas, but maybe they wanted to go Nike, or they're stuck with On, but they wanted to maybe, go with Lululemon or a different brand. And so I think just understanding it, we're all learning it. It's kind of build the plane while you're flying it with this. but it has been a very positive thing for our sport, especially as someone who is in a sport that's maybe less revenue generating than others, to have this opportunity for our student athletes. It's keeping them in the collegiate system and setting them up for a really good entry into the pro world.
That's a really interesting dynamic. And I'm sure, and you can tell me if I'm wrong, but the athletes will need to lean on coaches, particularly in a small sport where you have such camaraderie to help them make those decisions. Or
Yes.
hopefully.
Yes and no. I think the relationship that you have with your athletes, a lot of athletes are getting agents. That's a very common thing now where athletes have agents representing them. And so they can ask the Q&As. I don't understand the NIL contracts. Wasn't around. It's very new. And so having an agent or having someone that you can help read through the legalities of those NILs, I think is really important. So yes, I obviously have a favorite brand. We're a Nike school and I love Nike. But the athletes, we have, athletes on our team that represent different brands when they're outside of BYU.
That's very interesting. Thank you. Let's turn now to the submitted but not yet approved settlement agreement. Jessica, can you give us an overview of the primary terms of the agreement? And then we'll talk a little bit about procedure, where it's at now.
Sure. So there's two main components to the proposed settlement. One is monetary relief and one is injunctive relief. So for the monetary relief, the NCAA and its Division I members will pay $2.78 billion over a 10-year term to classes of current and former D1 student athletes for claims relating to NIL and other athletic services claims. It equates to approximately $280 million annually, and the distribution will be determined through methodology proposed by the plaintiff's expert. As for the injunctive relief, there's a couple of different components. First, during the 10-year term of the agreement, D1 schools can provide direct benefits worth up to 22% of the Power 5 schools' athletic revenues each year, which is currently expected to be about $22 million. That would increase annually as revenues increase, and student athletes are allowed to receive this compensation in addition to scholarships, third-party NIL deals, and other educational benefits. Institutions are able to pay student athletes directly for NIL rights, and those payments would apply towards that 22% cap, whereas the third-party NIL deals would not count towards the 22% cap. Though the settlement would allow NCAA to have new rules governing NIL payments. One key one is that they have to be made pursuant to true NIL deals, which means fair market value payments rather than pay for play payments. And there'd be a framework where the student athletes in their institutions have to demonstrate that the deal is actually a true deal and would have to disclose payments over $600 to a clearinghouse. And there would be an enforcement and oversight program along with these deals. The injunctive relief also contemplates eliminating caps for the number of scholarships per sport, and instead proposes roster limits. And then finally, the members of the class would agree to drop their claims against that NCAA for antitrust violations for 10 years, and allows a substitution system that would ensure that future athletes are able to opt into the revenue sharing structure over the 10-year term of the deal.
So the tenure of the agreement is 10 years.
10 years.
Okay. And then let's talk. So that those terms were submitted to the court. The court held a hearing and expressed some concern. And currently the plaintiffs and the NCAA are maybe not back at the drawing board, but are fiddling with some things and then will reappear before the court actually this week on September 26th. Tell us a little bit more about what's going on there, Jessica.
Sure. So at the preliminary approval hearing, the judge expressed concern in particular over the potential restrictions on NIL payments from third parties. And she asked that the parties go back to the drawing, she's hesitant to take away money from players if they're already receiving it. And she asked the parties to come back to her after looking at that provision. She also wanted clarification that the settlement does not release Title IX claims. And the plaintiff's lawyers have said they don't expect the deal to change drastically. That maybe this is a matter of communicating clearly, more clearly to the judge what the provision as drafted does and does not do. And so they will go back to the court this week, and we'll have to see what she says and whether they've satisfied her that this settlement should go forward.
There's been, and now I'm going to ask you to go out on a limb and use your litigator brain, but there's been some talk or bluster that if this doesn't satisfy the court, that the NIL restrictions are make or break for the NCAA and everyone's ready to go to trial. What do you see the odds of that happening? How do you read the tea leaves there?
I think that there's a lot to gain to get this deal done. And so I would expect that the parties are going to do their best to persuade her. But if it's at least the NCAA has seemed to make it clear that this is a real sticking point for them. And so if there are tweaks or different wording don't persuade her, then I think it's game on for trial. And yeah, we'll see what happens.
Yeah, I'm sure she will be cognizant of the fact that she doesn't want to take money away from athletes by restricting or blessing something that restricts NIL funds, but all bets are off if it goes to trial. And so I think everyone has an incentive to move, even the court, but always unpredictable. Liz, let's turn to you next. Jessica has laid out some of these primary terms for us. What are you observing in athletic programs across the country as they anticipate the potential settlement? How are they preparing? And then also, in your role as Title IX, you have insight into, as Title IX coordinator, you have insight into that legal landscape as well. How do you view this interacting with Title IX considerations?
Yes, thank you. So college athletic departments around the country are really viewing this as an opportunity to adapt and evolve. And it's not an opportunity without challenges, but it's definitely an opportunity. And there are really good people all over the college athletics industry that got into this business to help student athletes be successful and to learn and to grow and to achieve their dreams. And that hasn't changed. But there are some challenges in terms of how this can be implemented. Just to give a little background of how college athletic departments typically, how they are funded, the funding structure. Their sources of revenue, and those include football ticket sales, some from men's basketball ticket sales, media rights agreements, distributions from the NCAA that largely come from the NCAA men's basketball tournament, corporate sponsorships, private donations, school fees if you're at a public institution, and some schools have campus support as well, and all of that funding then funds all of your sports, and so there aren't many athletic programs around the country that have extra money laying around, because typically any extra money is just reinvested in all of our programs. It's reinvested in things like facilities, in coaches and athletic staff, in sports medicine staff, in academic support services, in gear, in the way that we travel, and obviously in scholarships and in that funding, in nutrition and meals and food and tutoring and on and on and on, mental health resources. And so the way college athletics have been typically funded, and those revenue streams and the way that money has been reinvested, now with this potential settlement and the opportunity to now directly compensate student athletes for their name, image, and likeness, it's again a great opportunity. but that means that athletic departments around the country are looking for new revenue streams, or how to maximize revenue streams in a way that they haven't before, and or find ways to be more efficient with how they're currently funding things. And so those are some of the challenges. And with such a quick turnaround of this, where it's expected that it will be done in a matter of months or years, that's posing some challenges. And you'll see athletic departments around the country really trying to examine, are there new revenue streams that we can tap into? Because certainly no athletic department wants to take away resources and support and things that are already there for our programs. But there's not many departments that have money just laying around that hasn't already been, used and budgeted out to support all of their programs. Some of the complications with the scholarship limits versus roster limits, the NCAA, there are two kinds of scholarships in the NCAA currently, and there are headcount sports and there are equivalency sports. And it's been that way for decades. And so some of our sports across the country, football, men's basketball, women's volleyball, women's gymnastics, some others are headcount sports, meaning if you're going to scholarship a student athlete, it's a full scholarship. There are other sports that determined by the NCAA, it's equivalency, meaning you get the equivalency of a certain amount of scholarships, but it's up to a coaching staff or an institution to decide how to distribute that among your whole roster. Well, now if the House settlement goes through, then essentially everything will be equivalency. It will be up to coaching staffs and institutions to decide how they spread that money around. And like was mentioned by Jessica, now there will be a roster limit instead of a scholarship cap. And so, some out there would say, oh, that's a wonderful thing. Then look, you can fully scholarship every single person on your roster. And that is wonderful freedom to be able to do that. But again, that's going to require new sources of funding, or looking at how to reallocate current funding to be able to do that, because there's not just money that's been laying around that can then be distributed to those additional scholarships. It also means that in some sports across the country, there will be roster spots that will be cut. Some athletic departments across the country function with large rosters that are above what the new roster limit might be. And so that means that now an unforeseen consequence is there are going to be less participation opportunities in some sports at some institutions, because that's going to be a new limit that wasn't there before, which is unfortunate. When this is all about helping support student athletes, that will be an unfortunate consequence at some institutions or in some sports. So there are a whole lot of moving parts to it. You asked in terms of Title IX, we don't have a lot of answers. We ask great lawyers and attorneys like yourselves for guidance on how Title IX will apply in terms of revenue sharing and NIL, and there's not a lot of answers to that. And so if you apply revenue share toward the sports that are bringing in the revenue and proportionate to that, well, then there may be a Title IX lawsuit that comes because of perceived, because of feeling like that wasn't an equitable distribution based on a participation opportunity. But if you then share revenue based on participation opportunities and make it equitable that way, well, there's a lawsuit coming because someone say, well, but my sport brought in the share of the revenue, so I should be able to, get that proportion of the revenue proportionate to what my sport brought in. And so there are just some real challenges that we don't have answers to, and we're hoping really smart people like that are on this webinar will give us some guidance to help us know how to best navigate that. Those are just some. I could go on and on, but a lot of challenges to it, but a real opportunity for us to evolve as an industry. And again, there are a lot of really smart people that work in this industry that got into it because they want to help student athletes be successful and live their dreams and inspire people by competitive excellence. And that has not changed. And so there are a lot of determined people that want to help figure this out to help our student athletes to be able to profit off this in a way that also helps us to be able to support all of our student athletes in a way that helps them to reach their dreams.
Thanks, Liz. There is so much to unpack here, and I am I'm not going to opine on your Title IX ensuing litigation question. I think it's really complex and very difficult. And one of the hard things about a settlement agreement is you don't have judicial guidance coming out of that necessarily on those issues. Diljit, let's turn to you and again take it at one level lower, abstraction. How do you expect the settlement agreement to affect student athletes specifically? And you can talk particularly about the sports that you're in, and then maybe any extrapolations on the broader student athlete population.
Yeah, for our sport, I think there's some real concern nationwide in talking to some of my athletes about protecting the integrity of opportunity. And there's 190,000 NCAA Division I student athletes. If this all plays out like it's looking like it may, that number may be vastly different because athletic departments around the country may not be able to have the resources to pick and choose to support all of those student athletes. And so I think our administrators are going to have a really big task in front of them, figuring out which sports they want to fully support, which ones. Some of the roster limits, that's being set by the NCAA. And so we're already seeing limited opportunities in our sport particularly that is going to change the experience of a potential student athlete that you may have been able to have in your program. The other part of it is sports are going to look very different than they do now. I can't foresee the future and see what that exactly is going to be, but you see the landscape's already changed, and this is going to be a more drastic change that is going to make some permanent changes to how we structure our recruiting, our teams, and really just which sports are going to, at which institutions are going to compete like a P5 and which are going to turn it into more of a club type of participation. But that's going to look different. We have a lot of questions at the coaching level. And I think the higher up you go, maybe some of those questions are answered, but we're in a phase right now where we definitely have a ton of unanswered questions. And I think until we figure out what happens with this settlement, we won't have the answers, because once that step happens, then the next step is how is it going to be applied at each institution. And so the part of me that knows we're a feeder sport for the Olympics, which all of us are having such good, nostalgia from what just happened in Paris with the 2024 Olympics. And all of those, majority of those student athletes were at a Division I, Division II program somewhere. And I want to protect that participation for those student athletes while understanding that there's going to be really hard decisions that have to be made. So, I'm really grateful that I'm in a position where I don't have to make those decisions.
Same. You mentioned, and I know you can't see, you don't have a crystal ball, but you mentioned, I think college athletics is going to look very different in the future. Do you mind expounding on one or two things that you think will be starkly different?
Yeah, for example, student athletes that were here 10 years ago, this looks very different than the world they lived in. They had restrictions placed upon them that are now laughable restrictions that we think about. Just like that, a decade from now, looking back, this is going to look very different. I don't know exactly in which way, because it's going to be dependent upon what ADs deem to be kind of the priority. It's part of it saddens me, if I'm being honest as a coach. I think that the pureness of what used to exist in college athletics it looks a little bit different, and there's more of a business mind that has to take place. Even as a coach, there's a business transactional piece to it, which saddens me because I like to think of college sports as being transformational. And I'm lucky I'm at a place where I feel like it still will be. But I don't think that's going to be true across the country. And so the unintended consequences of these decisions, which may be very beneficial to some student athletes, is that it's going to hurt some student athletes and the participation of some.
Yeah, that makes a lot of sense and reflects some, I think, widespread concerns about how this might play out. And I know this will make me sound nerdy, but I read your Runner's World bio that they did on you, and I know you like to treat your athletes in a very personal way, having them in your home, and so that would be very important in your teams. And I have no doubt that you will be able to maintain that in some respect, but it does change a little bit. One more follow-up for you, Diljit. I know as part of the Nike role that you took on, you think about women's sports and women's experience in sports specifically. Do you have concerns around gender disparities with the settlement?
I am probably different than most. I do not. I trust that the people who have paved the way and been trailblazers for women's sports to get to where it's at now, which I don't think is a movement. I think it's the standard. This is what we are now operating like. And so while it may look different for some sports, I do think we have enough people in the right place in positions of leadership to make sure that we protect women's sports. And Title IX may look different. And maybe it's time for it to evolve and look different. But I am a strong believer and have the utmost faith and confidence in women's sports and where we're going.
That's very optimistic. And if you and Liz, we do, of course, this panel is an example of having women in the right places to make these decisions. We have a question for Liz and Diljit from webinar participants. How might the settlement affect the competitiveness of college athletic programs? You've both touched on this a little bit about schools maybe having to pick and choose, but we'll start with Liz and then go to Diljit. And can you expand on that? And it's interesting, we're here because we're an antitrust series, and the suit talks about competitiveness at a high level, at a restraint level. But now we're going to take it down and talk about the competitiveness between sports and between schools. And what do you see the outcome on that front?
It's a great question. So when you think about competitiveness, you can think about as a whole athletic department, you can think about individual programs. And some programs, some athletic departments pride themselves on being very broad-based, that if they're going to have a team, that they want to give that team everything they need to win a national championship, compete at the highest level. There are other athletic departments across the country that really have honed in on a couple of their sports and saying, these are, and kind of tiered their sports, so to speak, and saying that, we're going to put all our resources here. We're going to have some other opportunities here, but we're going to go all in on these 3, 4, or 5, sports. And so you see that across the NCAA, different athletic departments do it in a different way. I think if the settlement goes through, one thing that you'll see athletic departments thinking strategically about what they want to be. And those that are more broad-based, will they continue to be broad-based, or will they decide, okay, now's a time for us to look more at different sports and how those are resourced, again, because of this limited resource and depending upon being able to identify new revenue streams. But you look at, and Diljit, I'm sure we'll talk more about this, the lifeblood of any athletic department and its success is its student athletes and recruiting. I mean, certainly you need to have great facilities, great coaching, great support services, all of those things. But the reason for that too but the lifeblood is the talent and the hard work of these student athletes. And so, pre this settlement and even pre NIL, you think of how you recruited student athletes, what made them want to come to your school. And certainly the scholarship was a huge part of it, but it was, okay, where am I going to get the best coaching? Where am I going to get the best facilities? Where am I going to get the best gear? Where am I going to get the best education? Where am I going to be set up for the rest of my life, whether I go pro or whether I go to graduate school or whether I go right into a different industry? Where am I going to have the best school environment? Where's going to be the best competitive environment? Where am I going to get the best exposure and media coverage? All of these things, where am I going to get the best medical services and support services for mental health and career services? Where's the best nutrition and strength conditioning program? You look at all these things. And so, athletic departments have poured in resources to all of these things to support our student athletes and attract student athletes there. Well, then in 2021, with that change, then you add on NIL to that, and that becomes a factor, a determining factor for prospective student athletes and where they decide to go is, well, what do those NIL opportunities look like at that school? And then you add in the transfer portal and those changes, and you see more and more of now these two, these new factors of more freedom to transfer and NIL opportunities that are then equating into the decisions that they make. And so then you look at House and what's happening there and the opportunity to revenue share and how different departments are going to decide to do that and what will that look like. That will be another data point that prospective student athletes or transfer student athletes will use in determining their decision. And so there's going to be sort of this reshuffling of how schools do it, of where they decide to put those resources and how. And so it'll be a couple of years, I think, before you see things sort of settle again into what the new landscape looks like. In the next few years, there's going to be a lot of that shuffling of different athletic departments, different conferences, and everyone deciding, okay, where strategically do we feel like we need to invest to benefit our student athletes and our whole athletic department?
It'll be interesting to see where it lands. One follow-up before we move to Diljit on that same question. Liz, you mentioned all these factors. It's a matrix, and obviously students are going to prioritize things that are most important to them. Have you seen since 2021, is there a predominance to NIL funding for those students who can receive that? Does that tend to weigh more heavily than the other factors that programs have put so much resources and energy into, or is it still very student specific, very what's important to who?
I think if you look across the country and look across sports, especially those sports that have more robust NIL opportunities, typically, it absolutely is a huge factor. How could it not be for an 18, 19, 20, 21-year-old making important life decisions? How could it not be? It's a huge determining factor. And the other things are all still very, very, very important. It's not student athletes aren't just following money because these other things are very important to their experience and for the investment in their long-term success as an athlete, as a student, and as a professional. So absolutely, it's a strong determining factor, but it's not the determining factor. These other aspects are very important as well.
Thanks, Liz. Diljit, we'll go to you now on the competitiveness question and what you see the effect of the settlement agreement on the competitive landscape to be.
When you look across the NCAA currently, the programs that are at the top, that have been at the top, that have a tradition and a deep legacy in their sport, they are supported and invested in. That is going to continue to be the same. You may have a one-off one year where a program just, maybe more in the tournament, right? You have that Cinderella team that people kind of the underdog. In our sport, there aren't many Cinderella teams. The ones that rise to the top and the ones that are at the top have investment. And so you're going to continue to see the programs that are at the top battling for national championships, battling for those podium finishes are going to be teams that are invested in, that administrators felt it was necessary and important to put them as a priority sport and invest in them. So investment is a competitive advantage. That is not a secret. And that will continue that has been true. That'll continue to be true. Over the 300 Division I programs, there is a big discrepancy right now in some of the top programs' investment and what scholarships look like. Some don't fund to a full scholarship allowable limit, and some do. And that does show on the cross-country course. It shows at national championships. And so you'll continue to see the competitive advantages with the support financially that they're receiving.
That makes perfect sense. And it's just, we'll have to see where the investment goes as we see the settlement evolve. I think we have time for one more question. And this one, you can all speak to this one, whoever would like to chime in first. If you could change something or tweak something in the settlement agreement, whether that would be eliminate something or provide more clarity to something or add something, is there something that you think would improve the agreement and improve student outcomes?
I would love a pay and protect model. Like, let's pay, let's do revenue sharing, but let's also protect the integrity of all sports. And that's not possible, which is why we are in this settlement. So that's my piece on it is I'm not against this new evolvement of NCAA athletics. I actually think there's a lot of good to it, but I would love if there was some protection for just opportunity and what that there's a commercial that always plays during March Madness where there's, blank thousand number of student athletes. All of them, this percentage is going to go pro in something else. And the ability to go pro in something else is enhanced by your experience as a student athlete. C-level execs that are female, 94% of them played a sport in college. I want to just protect the opportunity. And so that's important to me, pay and protect.
I love the way you put that. Succinct. Good luck to those who have to come up with the protect terms of the agreement, but I would love to see that in there too. Jessica, Liz.
I guess I think that the Title IX issues are going to be really, really muddy. And I don't know that the settlement's exactly the right place to do it, but I feel for Liz and other administrators who are going to have to navigate this landscape. And maybe that's related to the protect in some way. Of just, yeah, again, I don't envy who would have to come up with it, but find a way to kind of give some more guidance as to how the settlement would interplay with Title IX obligations.
That makes sense. Hard to do in a settlement. You can't make a judicial decree or interpretation.
Correct.
But also hard to see how that gets interpreted outside of subsequent litigation, which is unfortunate. Liz, how about you?
Really just what's been said, the very same thing. It would be helpful to have some more guidance on the interpretation of Title IX and how that might be seen in terms of revenue sharing, and some more clarity to help us know then how we can resource programs to help broad student athletes, male and female student athletes across sports, regardless of their revenue generation. And so that's probably a pie in the sky, but I would love that. That would be really helpful to us. And I think athletic departments across the country would welcome that guidance and help.
Makes a lot of sense. We've had a really fantastic discussion. I think that's a good question to end on, but I want to give you each an opportunity if there's anything else that you want to leave participants with. This is your time. All right. Well, thank you to our panelists. Thank you to everyone who joined this webinar. BYU Future of Antitrust series will be putting on more programming like this, and we will send out flyers and notifications for that. So register next time, and have a great day, everyone. Thank you for joining us.